Hello and welcome back, students, to another civics class today. We will be looking at a lesson from 8th standard civics textbook, the Indian Judicial System. Till now, we have learned about the parliament and the legislature and the executive. Today we'll be looking at the third pillar of the democracy, that is judiciary. So let's get going. Along with the legislature and the executive, the judiciary too is an important organ of the government. While the legislature makes the laws and the executive implements the laws, the judiciary gives justice. In this chapter, we will learn how judiciary works to give justice and thereby helps in removing injustice in a society and establishes a healthy society. So let us look at the points that we are going to study. We will be looking at the introduction of the judiciary, the structure of the judiciary, that is, the judiciary is formed of which all subtopics or subdivisions. We will also look at the Supreme Court, which is the highest authority in the judicial structure. Then we are going to look at the judicial activism, that is, in what manner can even the people be a part of the judicial process. Then we are going to look at the district and the lower courts and also the different branches of law in our country. So first let us understand why giving justice is important and necessary. Well, sometimes in our country where we have such a great amount of variety in our opinions, in our thoughts, in our perspectives, the beliefs, faith, and culture of the people, there are bound to be differences of opinions. That is, when there is so much variety in the people among us, in the different languages that we speak, in the religions that we follow, in the habits that we have, so there are bound to be differences, and because of these differences, if people are tolerant, then they can avoid conflicts. But if the differences of opinions that the people have are very sharp, then they may create conflicts. And when these become conflicts, then the conflicts have to be resolved or have to be solved in a very impartial and unbiased manner. That is, impartial and unbiased means without taking sides of any of the people, justice should be given. That is what is impartial and unbiased mean. So for this justice to be given impartially and in an unbiased manner, the judicial machinery or the judicial system also should be impartial and unbiased. So which is why we see that justice is needed to be given to the people, and that justice that is given to the people should be impartial and unbiased. Let us try to understand why we need laws, or why should there be separate laws. Well, the first reason is that sometimes conflicts may arise between individuals, that is between two individuals, or it may also be between the individual and the government. Now, in the case when it is between individuals, then the people will directly approach the court. But what happens when there is a conflict between the individual and the government? In that case, there has to be a law which is even above the government. And hence, laws have to be made which can resolve the problems that occur between the individual and the government also, so that people can approach the court of justice even against the government. The second reason is that government tries to implement the objectives of social justice and equality that are laid down in the Constitution. The government of India has already given the citizens the right many rights and the right to social justice and equality also. Now, the judiciary, through its decisions in certain cases or through the active involvement, can support the government in these implementation of social justice and equality. So, to establish social justice and equality in the society, also laws need to be made. The third reason being that the courts can also help the government to bring the weaker sections of the society, women, children, differently abled, and the transgender communities into the mainstream of the society. These are the societies which have been from many centuries targeted as the minorities, and hence we find that sometimes they may not have been given their due in the society, their place of importance in the society, but through the laws the judiciary can help the government to protect the rights of these weaker, so-called weaker sections of the society. Moving on to the next point, when the common man benefits from the values of freedom, equality, and justice, it leads to the widening and deepening of democracy. Well, the widening and deepening of democracy, that is, the common man's beliefs and faith in the democratic system and in democracy, this belief, this firm belief is necessary for the strengthening of the democracy. So, through the medium of laws, we can help preserve the values of freedom, equality, and democracy. Moving on to the next point, well, the rule of law is protected by the judiciary. That is, the judicial courts, they protect the law. The law treats everyone equal, the rich, poor, developed, backward, men or women. All are equal before the law, and all the citizens of the country have the fundamental rights which are available. And hence, these ideas are expressed clearly through the judicial decisions that are taken through these courts. Moving on to the next rule. Now, the judiciary helps to protect the rights of the people. Conflicts are resolved in agreement with the law, and the law prevents the emergence of repressive and authoritarian groups and individuals. So, it is with the help of the law that and the judiciary that we can avoid any individuals gaining authoritarian power or groups which may become authoritarian. So, these are the different reasons why we need laws in our country, why we need a judicial system in our country. Let us now try to understand what are the different components or the branches of this judiciary, which is now entitled as the structure of the judiciary. Well, India is a union of states. The centre and the constituent states have a separate legislature and executive body. That is, the central government has a separate legislature and executive body, whereas the states have a separate legislature and executive to handle the affairs of their own states. But when we look at the judicial system, then there is one judicial system for the whole of India. We find here that there is no division of courts between the centre and the constituent states. This means that the judiciary in India is an integrated system. It is not divided between the state or the central government. The Supreme Court is at the apex, that is the main court, the Supreme Court, the highest court in India, and under it there are the high courts. The high courts control the district courts which deal with civil, criminal and revenue matters. Whereas under them also come the Nyaya Panchayats, which are at the local level, which are at the local government, self-government level. Let us study a little bit more in detail about the Supreme Court in India. Well, the Supreme Court is the highest court in India. It is the final court of appeal. The Chief Justice of India heads the Supreme Court of India. It is the President who appoints the Chief Justice of India and the other judges of the Supreme Court. By convention, that is by tradition, the senior-most judge of the Supreme Court is also appointed as the Chief Justice of India, that is the most important judge of India. Well, the judiciary should not work under any kind of pressure. The independence of the judiciary is maintained so as to enable the judges to fearlessly and freely carry out the function of giving justice. For this purpose, the Constitution has made certain provisions. Let us study them. The Constitution lays down the eligibility criteria for the judges. That is, how can one be selected or how can one become the judge of the Supreme Court. A legal expert or one having served as the High Court judge or an experienced advocate is considered eligible for this post. The judges are appointed by the President. This helps to avoid any political pressure because, as we know, the President is not belonging to any political party. So, when he is appointed by the President, then he is not from any political party. So that removes the pressure of any political party. The judges enjoy security of tenure. That is, they cannot be removed from their post for smaller and trivial reasons or for political motives. The retirement age of the judges of the Supreme Court is 65 years, while for the High Court it is 62 years. The salaries of the judges are drawn from the Consolidated Fund of India. No discussion takes place on this issue in the Parliament. Personal criticisms cannot be made on judges for their acts and decisions. They are fully free to take any decision based on the facts of the case. Contempt of court, that is going against the judge, speaking against the judge, is considered a punishable offence. This not only protects the judges from misguided and wrongful criticism, but also preserves the independence of the judiciary. The Parliament cannot discuss the decisions of the judges. Whatever decision the judges give, it is to be considered absolutely correct. However, it has a right to remove the judges from their position through the impeachment process. Let us now study the functions of the Supreme Court. Well, as a federal court, it has the responsibility to settle the dispute between the Union and the states, between the states and the Union, and any state on one hand and one or more states on the other hand. So, any matter regarding the problems between two different states or between one state on one side and many states on the other side, or between the central government and one state, all these matters are resolved only by the Supreme Court. The Supreme Court may also give orders for protection of the fundamental rights of citizens. That is, if any citizen feels that his fundamental rights have been not followed upon or not, he has been denied from his fundamental rights, then they can approach the court and the court can take a decision in favor of the citizen. The Supreme Court also has to review decrees and orders of lower courts and also review its own decisions. That is, if any lower court has given a particular decision in a particular case, then they can also approach the Supreme Court and the Supreme Court can review the decision. In case the President asks for the advice of the court to understand the legal aspects in matters of public importance, then the courts, that is the Supreme Court, has to provide the necessary advice. Let us try to understand what is this judicial activism. Well, judicial activism simply means that how can the citizens of the country also participate in the judicial process and thereby make the judiciary more active and more approachable to the public. Well, in this regard, PIL, the PIL has been very helpful to bring individuals and the judiciary closer to each other. So, what is this PIL? Well, PIL or the public interest litigation is a legal tool which allows individuals, groups, and communities to challenge the government decisions and activities in the court of law for enforcement of the public interest. It serves as a protection of the public interest and which directly joins the public with the judiciary. So, this gives a weapon to the public to demand from the government if the government has gone against the public interest. Traditionally, the court would settle the disputes only when they were approached for that purpose. However, in the last few decades, the image of the court has undergone a change and they have become increasingly active. This means that the court now seeks to fulfill the constitutional goals of justice and equality. The courts have tried to provide legal protection to marginalized sections in the society, that is, women, tribals, workers, farmers, and children. And the PIL or the public interest litigations have played an important role in this regard. The public interest litigation refers to litigations that are filed on issues of public importance by individual citizens, social organizations, or non governmental organizations on behalf of all the people. The court thinks over the questions raised by these PILs and gives its decisions. Let's try to understand the meaning of judicial review. One of the most important responsibilities entrusted to the Supreme Court is the protection of the Constitution. You must be aware that the Constitution is the fundamental law of the nation. The Parliament cannot pass any law that violates the Constitution. Every act or policy made by the executive should be also consistent with the Constitution. If any law passed by the legislature or any act of the executive violates any provisions of the Constitution, the said law or act is declared illegal and struck down by the court. This power of the court is known as judicial review. Well, the question arises that should the court have such a law, such a right? I think the Supreme Court should have this right because only then can the Constitution be protected. Otherwise, the legislature or the executives can get carried away and they can make any kinds of laws without regarding the Constitution. So it becomes utmost important that the Supreme Court be given such a right where it can even question the parliament of the country. Let us study the High Courts. The Indian Union of States confers the Parliament with the power to establish a High Court in each constituent state in the Union. Currently, there are 24 High Courts in India. There is a Chief Justice along with the other judges in the High Court. All the judges of the High Court are appointed by the President. The Bombay High Court's jurisdiction or power covers the states of Maharashtra and Goa and the Union territories of Dadra and Nagar Haveli and Daman and Diu. Let us try to understand the functions of the High Courts. The first function is to supervise and maintain control over the lower courts in its jurisdiction. Second, it has the authority to give orders to protect the fundamental rights in the state. And third, the governor seeks the advice of the High Court while appointing judges in the district courts or the lower courts. Let us also study the district and the lower courts. Well, these are the courts which are at the district and the tehsil or the taluka level. The people generally go to these courts. Every district court has one district judge. The branches of law in India. There are two main branches of law in India, that is the civil law and the criminal law. The civil law deals with conflicts which affect or interfere with the rights of a person. For example, conflicts regarding land and property, rent agreement, divorce, etc. After filing a petition in the relevant court, the said court gives a decision. Let's move on to the criminal law. Serious crimes are dealt under criminal law. For example, theft, robbery, dowry, murder, etc. In these cases, the first step is to file a first information report or an FIR with the police. The police then investigates the matter and then a petition is filed in the court. If the charges are proved, then there are provisions for severe punishment. So today in this lesson, we studied the judiciary in detail. The Indian judiciary has made a significant contribution in development of the country. Common people have a lot of respect and trust in our judicial system. The judiciary in India has protected individual freedom, the federal system and the Constitution of India. And courts have played an important role in strengthening the democracy in India. With this, we come to an end of the lesson. I hope you have understood the lesson, children. Thank you for listening to the whole video. Please subscribe to our channel for more such videos. Happy learning.